Okay, we're going to start the session. Good morning, and thank you all for coming. I'm delighted to see you all here. Welcome to the first panel of the third annual Critical Race Studies Conference, Race in Colorblind Spaces. Now that title, Race in Colorblind Spaces, sounds somewhat oxymoronic. For how can race be operating in a domain that we've said is colorblindness? One answer to that might be to call something colorblind, Justice Clarence Thomas, is not to make it so. But then that just begs the question about what colorblindness ultimately means, and that's one of the central issues we'll take up over the next 2 days at this conference. What exactly does colorblindness mean ideologically? What exactly does colorblindness mean as a matter of legal mandate? What does colorblindness mean in terms of its socio-economic effects? How do we see colorblindness? And we might think of that question both empirically, which is to say, what are the predicates on the ground that justify the attribution of colorblindness? And we might think of that question normatively as well, which is to say, how should we view colorblindness? What meaning should we attach to it? Here we'll think about whether colorblindness is operationable and what are the mechanisms and the effects of operationalizing colorblindness. We will look at colorblindness across a number of domains: policing, employment, the educational context. We'll think about colorblindness in terms of domestic politics, foreign policy, and we'll examine colorblindness at a number of distinct levels as well. That is to say, at the level of individual interactions, at the level of institutional structures, governance norms, and at the level of macro politics. It is very fitting that students will initiate this conversation. 4 students in interdisciplinary collaboration, 2 law students, 2 students in the field of social psychology, will kick off this event. This year marks the 20th anniversary of the Critical Race Theory Workshop, and students played a critical role with respect to the formation of that workshop and with respect to the formation of critical race theory more generally. So it is entirely appropriate that we begin this event employing a student panel as a point of departure. So, as I said, we have 4 speakers. The conversation will begin with Jordan Woods, our first speaker, who is a third-year law student at the law school and a member of the Critical Race Studies concentration. Colorblindness, as you are aware, has several discursive travelers, one of them being race neutrality. And both race neutrality and colorblindness might work as an ends or as a mean, which is to say, sometimes colorblindness is invoked as a means to get us to a race-neutral end, and sometimes race neutrality is invoked as a means to get us to a colorblind end. Underwriting this means-end analytic is the notion that the formal removal of race is what produces race equality. Jordan's presentation will test this hypothesis in a specific doctrinal context, that is to say RICO, and ask the question of, to what extent does this statutory regime produce racial effects, notwithstanding that it's formally inscribed in race-neutral terms? So we'll begin by thinking about RICO, race neutrality, and its effects. So please join me in welcoming Jordan Woods.
So I want to thank you all for coming today, and Professor Carbato for moderating the panel, and the UCLA Critical Race Studies program for giving me the opportunity to present my research. My project provides the first racial critique of the application of the Federal Racketeer Influence and Corruptions Act, formerly known as RICO, to criminal street gangs. Now, many of you in the audience may already be familiar with RICO. The statute was originally enacted in 1970 to dismantle the mafia and later expanded to target government corruption and white-collar crime. The statute was first applied to criminal street gangs in the 1980s, and this application has become much more frequent during the previous years. Now, through my own empirical research, I show that the racial identities of the individuals who have been prosecuted under RICO for criminal street gang crime have been predominantly minority racial identities. My thesis of the paper is that specific manifestations of racial bias are underlying RICO's current application to street gangs, and thus we could think of the application of RICO to criminal street gangs as a form of racial discrimination. Now, given the theme of the symposium, Race and Colorblind Spaces, my presentation is going to focus on three aspects. First, I want to start with RICO's text and state, federal, and local definitions of criminal street gangs, which make no mention of race whatsoever, and in this sense are colorblind. Second, I want to present my empirical analysis, which shows that the overwhelming majority of individuals who have been prosecuted under RICO for criminal street gang activity have been racial minorities. Finally, I want to conclude by giving my own take on specific manifestations of racial bias that are driving this disparity. Thus, although RICO is a colorblind law, racial biases are very present in its application to criminal street gangs. Now, I go into this in more depth in my article, but I want to quickly note that RICO has a very racialized history. Before RICO's enactment, Congress and the American public were fixated on the mafia as an alien conspiracy, which was motivated by anti-immigrant and specifically anti-Italian and Sicilian sentiment. The conspiracy theory is illustrated by the fact that public theaters, as seen on the right, opened their doors to the public in order to view congressional televised hearings on how to combat the mafia. Now, moving to RICO's text, two specific subsections, which are shown at the right, have been applied to criminal street gangs. Now, on the right, I show the three fundamental elements that these subsections share. First, that the defendant is somehow engaged in some sort of criminal enterprise, either indirect or directly. Second, that the defendant has engaged in a pattern of racketeering activity. And third, that the crimes affect interstate or foreign commerce. As you can see, race isn't mentioned in either subsection. Now, a deeper reading of the first element is particularly on point with today's symposium topic. The definition of an enterprise, as you can see here, is very broad, doesn't make any mention of race or criminal street gangs. Now, generally, courts have upheld criminal street gangs as RICO enterprises, so the question then becomes, what definition of criminal street gangs are courts using to make this judgment? And here, I think that federal, state, and local statutory definitions are instructive. So I start with the federal definition here, which you can see is very broad and makes no mention of race whatsoever. Essentially, any group that has consistently committed felonies involving drugs or personal violence falls under this definition as long as there are 5 or more people. Now, state and local definitions, which I provide here, on the left, California's definition, on the right, Albuquerque, New Mexico's definition, are broader in some respects and more narrow in others. They're broader in the sense that the statutes only require 3 or more people as opposed to 5 individuals, like the federal statute, but narrower in that they provide for other identifying means, such as an identifying symbol, which aren't mentioned in federal legislation. Still, race is not mentioned. Now, besides statutory definitions, the U.S. Department of Justice has provided 5 factors to identify a criminal street gang. These aren't controlling law, they're merely guidelines. They don't mention race, and like the other definitions, prohibit a wide variety of activity. So, given the broad scope and race neutrality of RICO and criminal street gang definitions, we should expect a wide variety of group crimes committed both by white and non-white individuals to be pursued. However, as my empirical analysis suggests, the individuals who have been indicted under RICO for criminal street gang crimes have been almost exclusively racial minorities. So I want to start with my methodology, which I want to acknowledge is far from perfect. Now, 3 sources help me to make inferences about racial identity. First, the surnames of individuals themselves. And admittedly, exclusive reliance upon surnames doesn't always tell the racial identity of an individual. Second, the racial affiliation of the gang itself. Now, websites and gang databases help me to determine this. But this also has problems because a criminal street gang has a particular racial minority or racial affiliation doesn't mean that uniformly the members are one racial identity. I also look to release pictures or mugshots, and clearly judgments about race are here connected to my own personal assumptions about racial appearances. So recognizing the imperfections of each source, in almost all cases, I relied upon a combination of the three to conclude the race of indicted street gang members. Now, although each of these factors is a proxy for race, my intention was that in conjunction, the three would help me to at least make a reasonable determination about race. And so, despite its imperfections, I just want to highlight that this methodology really is the best available to study RICO's application to criminal street gangs, which is why I chose it. The FBI hasn't released statistics on the specific gangs that have been indicted under RICO, nor have they released statistics on the number of individuals. Moreover, constructing a database of indictments from published opinions available on Westlaw doesn't make sense for my project because so many RICO street gang members accept plea bargains, and therefore the number of people who are indicted aren't reflected in court opinions. So I'll move on to my results. Based on obtained sources, 1,286 individuals have been indicted under RICO for criminal street gang activity. On the left, breaking it down by individual, 95.2% were racial minorities. The empirical study yielded similar results based on the number of indictments. On the right, I break this down by group. Approximately 67 RICO indictments I found, 94% involved an indictment against a gang affiliated with a particular racial minority. Now, a qualitative assessment of the data also yields disturbing results. People of color have been prosecuted under RICO for being part of highly organized and geographically dispersed gangs, such as members of the MS-13, the Mexican Mafia, and the Crips, the MS-13 viewed here. However, people of color have also been prosecuted under RICO for committing crimes in association with very loosely defined groups. For instance, several members of the Diablos, an Atlanta-based criminal street gang, were indicted in March 2003. The indictment just alleged that they used profits from drug racketeering in order to promote rap music. Or consider an indictment filed in 2003 against 5 members of the Third Ward gang. Similarly, a local gang just engaged in criminal drug trafficking in Petersburg, Virginia, and that was all that the indictment alleged. Now, interestingly, similar group activity committed by groups of white individuals is not being conceptualized in terms of RICO criminal street gang activity. So here I have an example from 2008, 15 people suspected of drug dealing and in connection with a prescription drug ring in Pennsylvania. And even though the drug ring was cohesive, there's a clear structure, as you can see, and the crimes qualified as predicate RICO crimes, RICO charges were not pursued. In fact, the only white criminal street gangs that have been prosecuted under RICO are white supremacist gangs and motorcycle gangs, 2 groups which I argue are already ostracized by mainstream society. So in 2002, members of the Iron Brotherhood, a white supremacist prison gang, were prosecuted under RICO. In 2003, members of the Iron Culture, another white supremacist group, were prosecuted under RICO. Hell's Angels, the infamous motorcycle gang, was the only white-affiliated, non-white supremacist group targeted under RICO in 2005. However, not all white supremacist gang crime activity is being pursued under RICO. So consider the white supremacist gang Public Enemy No. 1, which is shown here. This gang has been labeled by the Anti-Defamation League as California's growing racist gang. Penn members tattoo themselves with numbers and letters of the group or to identify themselves, and they've been heavily involved in drug trade, violent crime, illegal weapon possession. They've also become increasingly involved in white-collar crime, credit card fraud, counterfeiting, and identity theft, all RICO racketeering crimes. Now, interestingly, in December 2006, the police officers conducted a sweep of this gang. The suspects were charged with a variety of charges, including conspiracy to commit murder, illegal weapons, narcotics, forgery. But despite that, all of these charges qualify as RICO racketeering crimes. RICO street gang charges weren't pursued. Now, I think that these findings fit quite nicely into the theme of colorblindness. Generally, white criminal street gangs are only targeted under RICO when race is explicitly connected to their criminality, such as white supremacy. However, this is not the case for racial minority street gangs, which are targeted when race is not explicitly connected to criminality. I think there's a point here about colorblindness, which is the fact that racial minorities fall under RICO's target when race is not explicitly linked to criminality isn't evidence of colorblindness, but rather it's about explicitness of raceness and in the construction of criminal street gang crime itself as group crime committed by racial minorities. So I think that this point leads nicely into 2 points that I address in detail of my paper, which is that specific manifestations of racial bias are driving RICO's criminal street gang indictments. First, I posit that racial stereotypes are driving these prosecutions and how criminal street gang crime is conceptualized. These stereotypes transform race-neutral definitions of criminal street gang crime into one that's racially slanted. Now, stereotypes of criminal street gang activity are most evident in pop culture references. Take gangster rap in the late 1980s and early 1990s. Now, gangster rap was an important outlet for young artists to communicate their daily struggles with racism and poverty. However, through its explicit lyrics, it also spawned widespread images of racial violence and crime. Now, cultural scholars have criticized the media's portrayal of gangster rap, and more specifically, the coverage's effect on the construction of black male stereotypes. But I think that this construction also goes to how crime is conceptualized. Consequently, I think that most Americans conceptualize gang violence as only involving people of color. Now, second, I think that we could look to the fact that the disparity is also driven by the structure of law enforcement programs themselves. A recent surge of anti-immigration sentiment has culminated into a troublesome partnership between law enforcement and immigrations and customs enforcement. Created in February 2005, so 4 years ago, Operation Community Shield pools resources to simultaneously combat street gang and immigration crime. RICO is one of the tools in the program's arsenal to conduct sweeping arrests of alleged gang members. Since the program's inception, an astonishing 10,000 arrests have already been made under various criminal and civil laws. Now, the exclusive targets of OCS operations have been individuals of Mexican, Central, South American, or Caribbean descent. Therefore, if the available resources to target criminal street gang crime are being pooled to simultaneously combat immigration crime, then racial minorities will almost always be the exclusive target of OCS programs. So I think that we should only expect the racial disparity of alleged street gang members indicted under RICO to worsen as OCS continues its operations. Now, this finding regarding OCS brings me to my concluding points, which revisits the theme of colorblindness in RICO's history. So I think it's very likely that during the mid-20th century, RICO wasn't thought of as a racialized endeavor, and only after criticizing the historical environment in retrospect do we see RICO's discriminatory roots. Now, the purpose of my project is to make a contribution in order to prevent history from repeating itself and to warn against accepting the notion that RICO is a colorblind statute in its application because of its neutral language. So I think under closer scrutiny, which is what my project does, the stereotypes and sentiment underlying RICO's current application to criminal street gangs shows that it's a form of racial discrimination. So I thank you very much, and I look forward to your comments.
Thank you very much, Jordan. So that presentation makes perfectly clear that one of the dominant ideas about color blindness, that the formal elision of race is racially neutral, can be contested. And it can be contested not just in terms of its disparate effects, but also in terms of how categories like street gang, which is not explicitly racialized, is in fact racially inscribed in terms of how we understand it. So another dominant idea about color blindness is that it is a monolithic discourse with a monolithic valence. It's either good or all good, to use the camp expression, or all bad. Well, Ruth Tillman's presentation will help us think about that. Part of what her presentation will do, I think, is to raise a question about whether or not we might think of colorblindness as a multivalent ideological structure, at least in terms of how blacks experience that idea. So please join me in welcoming Ruth Tillman, who is a PhD social psychology student at Yale University.
Hello, thank you everybody for coming to this panel, and thank you to the organizers of this conference for inviting me to be a part of this panel. I'm really delighted about that. So, how do I make this up? Okay. So the title of my talk today is Colorblindness Always Negative for Black Americans and the Dynamic Meanings of Colorblindness. And this is work that I have conducted. I'm a second-year social psychology graduate student at Yale, and this is work that I have conducted with my advisor, Valerie Purdy-Vance. So I want to start with a quote from Obama from his famous address at the 2004 National Convention. And here he said, "I think that there's the possibility that I can't just win an election, but can also transform the country in the process, that the language and the approach I take to politics is sufficiently different, and that I could bring diverse parts of this country together in a way that hasn't been done in some time." And so what I would like to argue is that maybe the language that Obama is using isn't so different after all from the language that previous political leaders have used, but that because of who he is and what his identity is, he is able to convey a different meaning with using the same language. And Obama is not the focus of my talk today, but I think that he presents a great example for thinking about how contextual features such as minority leadership shape the way colorblindness is perceived of by minorities and in particular blacks. So I'm going to show you two empirical studies that I conducted about this topic. But before we delve into these studies, I would like to just talk briefly about the meaning of colorblindness for blacks and for whites. So it's pretty widely known that whites generally tend to endorse colorblindness, and they think of it as the appropriate strategy to approach interracial relations. And some more recent work also shows that colorblindness as used by whites is not static, but rather dynamic, and that whites can use it with at least two different intentions. And so one intention is maybe more positive from the perspective of minorities. It's to achieve true equal outcomes for everybody. But another intention behind using colorblindness when whites use it is to maintain the current status quo and to sort of impose a white standard on everybody. And obviously that's a more negative intention behind the use of colorblindness from the perspective of minorities. So what I would like to argue is that because colorblindness is used in these different ways by whites, this creates quite a bit of ambiguity for blacks. So when they enter or face a colorblindness setting or talk to somebody in sort of an interpersonal interaction, and this person is endorsing a colorblindness view, they don't know in which way colorblindness is operating here or what intention this person has when using colorblindness statements. So the question becomes, how do blacks disambiguate colorblindness when they enter such situations? And so I would like to argue that there's at least two ways in which blacks construe colorblindness when they're in a colorblindness setting. And one is an identity threatening, and one would be an identity affirming construal of the colorblindness message. So an identity threatening construal would be to think of colorblindness as ignoring the special challenges associated with race. And I think that a lot of the previous research that has shown the negative implications of colorblindness for blacks has focused on this construal of colorblindness. And so some research has shown that colorblindness can lead to a lower sense of belonging for blacks, fewer opportunities in society, and also lower motivations for social change. Okay, but there's also this alternative construal of colorblindness that's more identity affirming, and this might be the way in which Obama is using colorblindness. So the idea is that we can overcome specific challenges associated with race and move beyond race. And so what I'm really interested in my studies and in this talk today is what leads the meaning of colorblindness from the perspective of minorities to shift from an identity threatening construal to maybe a more identity affirming construal. And because these situations are ambiguous, I think that minorities have to look for other contextual cues that can help them disambiguate colorblindness. So one example for this would be racial diversity of a setting. So if, for example, in a company or institution, the minority representation is high, this indicates for a minority person that there's a true commitment to diversity in the setting. And then this also suggests that maybe colorblindness is used in a way that seeks to truly promote equal outcomes for everybody in this particular setting. So the first study I'm going to present looks at how racial diversity can disambiguate colorblindness. And so In this study, we had black and white participants, and we exposed them to a company brochure that was either high or low in racial diversity. And all of these brochures featured a colorblindness philosophy as a guiding principle for the company's hiring policies. And we measured how much blacks and whites trusted the setting, and also more explicitly what they think about the hiring practices of the company. And so this is what the brochure looked like. You see, this is the high minority representation version. It's indicated by the minorities in the pictures. And then this is the low minority representation version of this. And then on the right, encircled in red, you see the colorblindness ideology that remains constant across conditions. And just to show you what this reads like, so this is just an excerpt from it. While other consulting firms mistakenly focus on their staff's diversity, we train our diverse workforce to embrace their similarities. And it goes on, and then your race, ethnicity, gender, and religion are immaterial as soon as you walk through our doors, right? Okay, as for our outcome measures, so the first one was trust. So this is a 10-item scale, and some sample items are, I would feel a sense of personal belonging at CCG, that's the name of the company, or I would like to work in a place like CCG. We also asked people to provide a short answer, sort of an essay-style answer about what they think about the company's hiring practices, to get a more deeper insight into their thoughts about the brochure. And so we coded that. We had two coders, a black and a white person, coding these responses, and one of the main categories that emerged was concerns about unequal treatment. Okay, so first about the trust items. So our hypothesis here would be that for blacks, but not white participants, if the company is high in racial diversity, that would lead them to trust the company more. And then this is what we find. So you see the y-axis represents endorsement of the trust items that I just showed you some examples of, and then the red bars represent the diverse brochures, and the green bars represent the non-diverse brochures. And on the left hand, you look at whites, and you see here that whether or not the brochure was diverse doesn't really make a difference for their trust in the company. But when you look at blacks, you see that if there was a higher minority representation in the brochure, they express more trust in the company. Okay, and then another hypothesis about unequal treatment concerns. So here the ideas that we walked in with was that blacks but not white participants would experience greater concerns about unequal treatment if the company is low in racial diversity. And what we see here, on the y-axis, we see concerns about unequal treatment, and this is on a 1 to 3 scale from weak to strong concerns. And when you look at blacks here on the right, you see that they experienced a lot stronger concerns when the company was non-diverse than when it was diverse. And so what this first study suggests is that racial diversity of a setting can shift the meaning of a colorblindness statement from identity threatening to identity affirming. Actually, I wanted to just show you some of the things that people said. So one quote, for example, from a participant was, "It's not right to ask people to ignore such a large part of their identity as race." Or another person said, "It seems like their work environment might be prejudiced," right? So these are the kinds of inequality concerns participants experienced when they read this brochure. Okay, so when thinking about the outcomes of these studies, we also considered that what it really suggests is that minority representation seems to be a proxy for equality or inequality that one might experience in the setting. And so in study 2, the goal was to test this idea of equality and inequality more directly. And so we thought to create a setting that conveys a sense of equality or inequality directly, and then look at how that might shift the meaning of colorblindness in the setting. And so to do this, we focused on the problematic condition, so to say, from study 1, which is the low diversity condition, the low diversity representation condition, and we also chose to contrast colorblindness with a less, what we would argue is a less ambiguous multiracial statement, so the idea of multiculturalism or value diversity. And so this is to show that that the shift in meaning is particular to colorblindness because it is so ambiguous, and it's not something in general about how blacks perceive racial ideologies. And so the way we tested these ideas was, so we had all black participants in the study, okay, And this time we manipulated, they read the same brochures, but we manipulated what kind of message about diversity the brochure featured. So it was either the colorblindness message, as before, or a value diversity message. And then we also primed participants with equality or inequality, and I'm going to explain this in a second. All of the brochures were featured low ethnic diverse pictures, and all the participants were black. And our dependent variable, again, was trust. So this is what the value diversity policy looks like. It says, while other consulting firms mistakenly try to shape their staff into a single mold, we believe that embracing our diversity enriches our culture. As soon as you walk through our doors, you'll appreciate the strengths that we derive from our diversity. So we would argue that that's a less ambiguous message than the colorblindness message. And now this is the prime, the equality and inequality prime. Now this is a method that's widely used in psychology. And the idea is that you give participants a word bank, and a significant number of these words are words that are associated either with inequality or equality. And then people have to find these words in the word search and circle them. And as they're looking for these words become activated and can then shape the way the brochure is perceived that they read right afterwards. So, for example, in the inequality condition, words that they were looking for are prejudice, and in the inequality, in the equality condition, something like fairness. So the hypotheses here were that blacks would trust the low racial diversity colorblindness company more when they were primed with equality than when they were primed with inequality. However, if the company had a value diversity approach, the prime shouldn't matter because that is a very non-ambiguous approach, so it doesn't really matter what the setting conveys in terms of equality or inequality. And so what we find here, so you see on the y-axis, this is again trust in the setting. And the blue bars are the equality prime, and so the fairness words, and the red bars are the inequality prime. And on the left, you see the value diversity statement, and you see here that the prime actually didn't make a difference for how much people trusted the company after reading the value diversity brochure. But when they read the colorblindness brochure, the prime made a big difference in that they trusted the company more. They were more likely to trust the company when they were primed with equality than inequality. And so to summarize, and study 2 shows that conveying a sense of equality, again, can shift the meaning of colorblindness from being identity-threatening to being more identity-affirming. And for some general conclusions, so this line of research suggests that there are indeed 2 ways in which blacks can construe colorblindness, one that's identity-threatening, one that's identity-affirming. And that indicators for equality or equality in settings such as high racial minority representation can determine how colorblindness is construed by blacks in this particular setting. And so I want to end with another quote from Obama. He said, there is not a black America and a white America and a Latino America and Asian America, there's a United States of America. And so the idea is, this obviously was perceived very positively by many minorities, and the idea is that when he made this statement, they were able to construe it in an identity-affirming way. Now, I would argue that maybe in Bush's that it might not have been perceived in the same way, and maybe it would have been perceived as a lot more identity-threatening and would have had more negative consequences in how minorities would have viewed the statement. And so as for future directions, one thing that I'm interested in is looking more at other features in settings such as high minority representation that can convey equality or inequality, and something to discuss maybe here would be what would be features of legal settings that can convey these different ideas. And something else is that I'm from Germany, and when I started this work with Valerie, we always talk about sort of internationally and how so many of these things are thought of very differently in Germany and in the context of immigrants coming to Germany. And so one thing that I would like to explore in the future is what the meaning of colorblindness might be in a European context or in the context of a country like Germany, with a very different history of immigration and very different racial composition and so forth. Thank you very much.
So I'm I'm tempted to just try and utter the words of Obama, there is no white America, black America, with his inflection, but I fear I would fail, so I won't do that. And you might not give me the pass that I believe he got with that particular articulation, which I'm not quite sure what that does for the juxtaposition of Bush against Obama. Maybe it would be me against Obama in that particular instance. So Ruth's presentation, at any rate, suggests that we should not think of colorblindness as a monolithic idea, that we need to move colorblindness outside of the good-bad frame, that we ought to think of our colorblindness as a function of context. Well, our next presentation will suggest that we ought to move colorblindness out of another kind of frame, that is to say, a domestic frame. To put it slightly differently, that we ought to transnationalize our critique of colorblindness, and this is the issue that Nina Farnia will take up. She's a joint degree student in law and public policy and also a member of the critical race studies program here at the law school. Her presentation will explore more specifically the connections among empire, colorblindness, and racialization, particularly as these three dynamics converge upon the nation of Iran via U.S. foreign policy and upon the bodies of people of Iranian descent in the U.S., irrespective of their citizenship status, as a function of racial interpolation. So please join me in welcoming Nina Farnia.
First, I'd like to begin by thanking my mentors on the project, Leo Estrada, Cheryl Harris, and Jerry Kong. I'd also like to thank Devin Carbato for putting this panel together, and then the CRS program for allowing me this opportunity. Thank you very much. Now, normally when we see the word terrorist used in the law or popular culture, we think of individuals or groups. But I'm interested in understanding how colorblind ideology, as it manifests in law and culture, functions to construct the state as a rogue terrorist entity. In this context, Iran is a perfect example. Iran and the United States have a long relationship which, historically, has vacillated from love to hate to love to hate. But the relationship between the two doesn't operate in a vacuum. It has had important effects on American politics and ideological struggles, as well as having an impact on the broader Middle East and Central Asia. And it will continue to do so, despite the presence of a seemingly progressive American president. Now, with regard to Iranians in the United States, the relationship between the two states has multiple effects, especially in light of domestic policy vis-à-vis Iranians. First, the U.S. considers Iranians to be white and officially categorizes them as such. But Iranian Americans are still Iranians. They come from Iran. And by extension, this whiteness becomes a framework of understanding Iran as well, a country which happens to be modern-day America's biggest enemy. So, what work does whiteness do vis-à-vis Iranian racial identity and American foreign policy against Iran? I contend that this attribution of whiteness has less to do with domestic politics and more to do with American imperial aspirations. That is, whiteness plays an important role in transforming the relationship between the nations from one of empire and post-colonial politics to one of equally empowered players at the bargaining table. First, we know that whiteness is a signifier for racial power. And, as I said, we are told that Iranians are white. So, these ideas about Iranians and whiteness are telling us something about the power that Iran has. Following this version of the story, Iran is not composed of the formerly colonized, colored masses challenging U.S. empire, but rather is a dangerous opponent threatening American national security. Thus, the attribution of whiteness to Iran and Iranians takes the neo-colonial relationship between the two and turns it into nothing more than a volatile relationship between two enemies, one civilized, the other uncivilized. As a result, the U.S. can then disavow its imperial aspirations and turn a story of racial empire into one of national security. In addition to whiteness, colorblindness plays a significant role as well, for it enables the simultaneous construction of Iranians as white, but still uncivilized, backward, and inferior. Historically, since Plessy v. Ferguson, the rise of colorblind ideology in the U.S. has more or less mirrored the rise of American empire abroad. And throughout history, as the U.S. became more serious about its imperial aspirations, Iran and Iranians increasingly figured into domestic, legal, and popular discourse. As the cases I'm about to cover will show, colorblindness is the ideological vehicle used to race Iranians. In essence, though Iranians are white officially and don't constitute a race of their own, they are still raced. And this is done by and through a collaboration between colorblindness and empire. The image I'm about to show is a perfect example of this operation of colorblind racial formations. Now, I felt conflicted in using this image because images of violence, I know, are reenactments of that violence. And there's so much in this image that I don't want to participate in reenacting. But when you Google Iran, this is the first image that comes up when you Google Iran. So this is an image of two young queer youth, one 14, one 16, being hanged for homosexuality. It was widely distributed in Iran, throughout the US and Europe a few years ago. And it helps us to understand how colorblindness functions to racialize Iranians. There's no text telling us what the image is about. You can't really tell anybody's phenotype from the image, so there's no explicit racial imagery. But there's still a racial subtext. We know this image is meant to depict Iran as a barbaric state, and it comes up when you Google Iran, so immediately you make the connection that this is from Iran. Notice that the hooded lynchmen in the back remind us of the hooded lynchmen in American history, a history that this country has disavowed. Thus, this image seems to externalize homophobia and violence from the U.S. as if, put simply, this kind of homophobic violence or state violence in the form of hanging doesn't happen here. So this image is an example of how colorblind ideologies actually function to achieve a racial project. The same function also occurs within the law. The first case I'll cover is a naturalization case from the 1900s. The second is an equal protection and immigration case from the period immediately following the hostage crisis. And the third is an employment discrimination case from March 2008. The first case, In re Halajian, is a naturalization case from 1909. Halajian was an Armenian who presented himself for citizenship, for naturalization, on the basis that he was white. He had arrived to the U.S. from what was then called the Ottoman Empire, the predecessor to modern Turkey. This is the Ottoman Empire at its peak. This empire lasted from the 1300s to 1923, a very long time, and ended immediately after World War I. The court thought of the Ottoman Empire as a Muslim empire, stating that when it conquered new peoples, it, quote, conversion to Mohammedanism and tribute were usually offered as alternatives to the sword. Mohammedanism was a pejorative term used to describe Islam at the time. These are various maps of the transitions that the Ottoman Empire went through. The first is, once again, the empire at its peak. And if you see right here, this is modern-day Iraq. This is modern-day Syria. It extended all the way into northern Africa and up into Algeria, modern-day Algeria, also into modern-day Europe. Now this region right here, right there is modern Iran. But the bits and pieces of this landmass on the edge were Iran at the time. Same here. This is immediately before World War I. The size of the empire had been reduced to this, but it still has some of Iran's land. And then here, after World War I, we see basically modern-day Turkey, the land reduced to that size. Now, notably, the end of the Ottoman Empire coincided with the rise of the U.S. role in what we know as the modern-day Middle East. In determining Halajian's race, the court begins by talking about color. But they come to the conclusion that race is not just phenotype. On the one hand, this quote represents a progressive intervention into the dominant racial theories of the time, highlighting how fluid race and racial formation processes actually are. On the other hand, this quote also lends itself well to colorblind ideology in arguing that race doesn't actually exist. The court goes on to argue that race is not an easy working test of white color, but that it includes in it ideals, aspirations, and standards, what I believe to be the court's language for ideology. Here you see how the court begins to define these ideals and aspirations that it speaks of. It talks about war and empire in the context of the Ottoman Empire, and references religion, specifically Zoroastrianism, Islam, and Christianity, to determine the side that the Armenians have taken in the battles. The term Persian fire worshippers is a pejorative term used to describe Zoroastrians, which was one of the predominant religions in Iran a long, long time ago. Ultimately, the court decides that Halajian is white. But what's important is that in a moment when the court is disavowing race and saying that it has no real meaning, it is still constructing Iranians as non-white. In effect, the court is using colorblindness to draw some sort of racial line. It is using Iranians to do it, and in the process, Iranians are kept on the outside. The next case we're going to talk about is Malik Marzban v. INS. It's from the period immediately after the hostage crisis, from 1981. Immediately after the Iranian Revolution in 1979, Iranian students took over the American embassy and took 75 American embassy workers hostage. Their aim was to put an end to the presence of U.S. spies in the country, of which it is said there were hundreds, possibly thousands. These hostages were held for 444 days, and every night at 10:30, Ted Koppel got on national television and he announced, "This is day X of the American hostage crisis." This lasted for 444 days. That show later became Nightline, and it is estimated that Nightline brought in 12 million viewers each night, leading one columnist to proclaim that ABC has finally found someone who can beat Johnny Carson, Ayatollah Khomeini. The interpersonal violence in the United States, which occurred as a result of the 1979 Islamic Revolution and the subsequent hostage-taking, was far worse than what we saw in the aftermath of 9/11. Most Iranian, Arab, and even some South Asians living in the U.S. at the time experienced some form of violence at the hands of angry, fearful Americans, not to mention state violence in the form of special registration, detention, and deportation policies. Malik Marzban was an Iranian couple who brought this case in 1981. They were visiting the U.S. lawfully at the time. They were immigrants visiting U.S. lawfully. During that time, in some circumstances, the Immigration and Nationality Act allowed for unlawful immigrants to depart voluntarily in lieu of deportation proceedings. Immediately after the hostages were taken, however, the federal government revised the INA. The revision required that with regard to Iranians and Iranians alone, the amount of time which the unlawful immigrant can depart voluntarily is limited to 15 days. The plaintiffs sued, claiming a violation of equal protection under the law, saying that this law is, quote, an emotional, patriotic, flag-waving reaction to the hostage crisis. The court frames this classification as one based on nationality, which can be sustained if it has a rational basis. Had the court treated this as a race discrimination case, it would have had to undergo strict scrutiny in order to survive, which is a much difficult test. Thus, the court deracializes Iranians and treats them solely as foreign nationals, who apparently are subject to lower levels of government protection, in order to allow the application of rational basis review, which then ultimately enabled this couple's deportation. While, again, in this case, there is no explicit racial language, the court argues that the expulsion and exclusion of Iranians is justified because these are nationals of unfriendly powers. Quote, the U.S. is not bound to treat the nationals of unfriendly powers with the same courtesy and consideration it extends to nationals of friendly powers. Once again, the court is drawing lines that look both ideological and racial, and Iranians are on the other side, the outside. In the final case that we're going to look at, it's from March 2008. The context in which it operates is very different than the others. By now, the U.S., and I mean now, the U.S. has developed a highly integrated empire throughout the Middle East in the form of troops, occupation, and the establishment of military bases all over the region. This is the total number of bases that they disclose, that the U.S. government holds. The majority, obviously, are in the United States, and of that figure, 4,402, nearly 500 are in California. That's by far the largest of any other state in the country. And then overseas bases, it's 823, right there. Now, the U.S. spends more money on the military than any other country combined in the world, all the other countries in the world combined. The majority of, many of the bases the U.S. currently holds are in the Middle East. This is a map, I think this is a little bit outdated, but it's the most recent map I could get my hands on. This is a map of all the bases that are in the Middle East. Now right here is Afghanistan, this is Pakistan. Here you have Arab countries, Saudi, UAE, Oman. This is Iraq, and then you go up into Turkey. Iran is this country right in the middle. There are no bases there because there are no formal relations between the two countries since the hostage crisis. This is the Caspian Sea. This is the Persian Gulf. So this region right here, and then this region like across, is a very rich resource region. Iran, before the sanctions were imposed, Iran produced more gas than any other country in the world, and was top 10 in terms of oil production. Now, Abdullahi v. Prada, which is the case that I mentioned, was brought in 2008. It's an Iranian Muslim woman brought it. She was an employee at Prada, and she was suing for discrimination. In her original complaint, she marked the race discrimination, national origin discrimination, and religion discrimination boxes. But in her amended complaint, she only marked religion and national origin. The decision was written by Posner, Judge Posner. He's a highly influential and very prolific judge and a former professor at the University of Chicago. Now, normally, Posner is someone who subscribes to colorblindness. In this opinion, however, he plays with race more than he normally does. He spends a great deal of time describing the phenotype, specifically the phenotype, of Middle Easterners and South Asians. And then, using that, he describes what race means, and he argues that Iranians don't constitute a race. But though they're not a race, they might provoke hostility associated with racism. So in this formation, he carves out the possibility of racism and marks it around the idea of a foreign race. Thus, ideas of a foreign race become compatible with colorblindness, allowing for a formal designation as white. Also, note here that Iranians provoke hostility. They're not victims to it. Ultimately, Posner decides in Abdullahi's favor, but despite that, he still does a great deal of racial work. He redefines the term Iranian, nothing more than a nationality, as a melding of national origin and race. And by calling Iran an enemy of the U.S. and Abdullahi a member of a foreign race, one is left to wonder whether Posner was arguing that Iranians are in fact perceived as enemy foreigners or even an enemy race, terminology we heard during the Japanese internment. As a result of this imperial context in which this case operates, the racial positioning of Iranians in the law looks different than before. Iranians are no longer on the outside as in Halajian, and no longer deportable as during the hostage crisis. So, they transition into becoming enemy foreigners, without, however, ever being an actual race. Now, if we think back to Halajian, recall that Armenians only become white over and against Iranians. And though that was exactly 100 years ago, we see in Abdullahi the same ideas of colorblindness used to racialize Iranians. In conclusion, though we like to think of colorblindness in the domestic context, in fact, it is also the ideology that enables the consolidation and expansion of American empire. To that end, it functions to blur the borders between outside and inside, the domestic and the foreign, white and colored. Thank you.
So each of the presentations we've heard thus far, it seems to me, have challenged a dominant frame of colorblindness. We began with Jordan, who challenged the idea that formally removing race from a statutory regime does not necessarily produce colorblindness. Ruth suggested that we ought to think about colorblindness outside of a good-bad dichotomy, that colorblindness can be good and it can be bad as a function of context. Nina pushed us to think about what it might mean to examine colorblindness not simply as a domestic concern, but a concern of foreign relations and a concern that might actually reflect U.S. imperial ambitions. Our next presentation will continue with that push. That is to say, we'll insist that we move colorblindness from a particular dominant frame. This time the frame is intergroup relations. What might it mean for us to conceive of colorblindness not just as a dynamic between, for example, whites and non-whites, but as an intra-group dynamic? Think, for example, about an institution that says we want racially palatable, meaning good blacks, but not racially salient, meaning bad blacks. That's certainly an issue that I think about in my own work. The next presentation by Danny Osborne, who is a social psychology student at UCLA, will force us to think about this precise question, this intra-group distinction in the context of the criminal process. Can we examine degrees of stereotypicality, and how do those degrees of stereotypicality shape the way in which colorblindness is understood and experienced? So please join me in welcoming Danny Osborne.
Thank you. Today I'm going to be talking about intra-group colorblindness in the criminal justice system. And specifically what I'm going to be focusing on are the implications for the criminal justice system, as well as our understanding of eyewitness memory. Ignoring within-group variation has for individuals' outcomes in the criminal justice system. But first, before I get started, I just want to highlight essentially the major theme of this conference, and that is this question as to whether or not colorblindness is, first off, something that we should pursue, and secondly, what are the implications of us pursuing an ideology of colorblindness. And while I don't mean to trivialize it by suggesting it's akin to sharing your toothbrush with a dog, I do believe that colorblindness does have some considerable implications for race relations. And in particular, as we've seen already today, following a colorblind ideology tends to reproduce the already existing inequalities between groups. What I want to highlight today, however, is the possibility that colorblindness can also operate within groups. That is, by ignoring within-group distinctions, we can further reproduce the inequalities that exist within a group. So, as I've already sort of hinted at, colorblindness has traditionally been conceived as an intragroup phenomenon. That is, we typically conceive colorblindness as something regarding differences between groups. That is, whites versus non-whites, whites versus blacks, etc. What I want to argue today, however, is that by ignoring within-group differences, we actually commit something akin to that at the intragroup level. That is, colorblindness can operate at the level of an intragroup phenomenon. So once again, when we're ignoring within-group variation in physical appearances, we can once again reproduce previously existing inequalities within these groups. And so what exactly am I talking about when I talk about within-group differences? Well, past research in social psychology has grasped onto this idea of perceived stereotypicality. Essentially, the degree to which an individual is phenotypically representative of their social group. And this is most easily demonstrated through visual demonstration. Essentially, what we have here is a picture of the same individual. However, the person his face has been manipulated to appear more or less representative of his social group. So this individual would be classified by the layperson on both the left and right photo as being an African American. However, as we can see on the photo shown on the left, we see that the person's skin tone is slightly lighter, His nose is a little thinner, as well as his lips are a little bit thinner than the person on the right. And once again, I want to highlight the fact that the individual would be classified by most lay people as an African American, regardless of which picture you're looking at. However, the subtle variations within the group can actually have some very serious implications for how they're treated, particularly by the criminal justice system. And so what exactly does this research look like? Well, we know from past research by Jennifer Eberhardt and colleagues that perceived stereotypicality is associated with perceptions of criminality. So essentially we see individuals who are high on perceived stereotypicality are viewed as more criminal, both by the layperson and by people within the judicial system, as being more criminal than individuals who are low on perceived stereotypicality. We also know that studies looking at shooter bias, that is the tendency for individuals to mistakenly shoot an unarmed black man at a higher rate than an unarmed white man, we see that this tendency is enhanced for individuals who are high on perceived stereotypicality. That is, individuals who are high on perceived stereotypicality are more likely to be victims of the shooter bias than individuals who are low on perceived stereotypicality. And finally, we also know from research by Irene Blair and colleagues, as well as Jen Eberhardt and her research team, that perceived stereotypicality also influences the type of sentences individuals receive. So individuals who are high in perceived stereotypicality are more likely to receive longer sentences and sentences that are more deadly than individuals who are low on perceived stereotypicality. So essentially, this research suggests that if we were to ignore these within-group differences, we would miss an incredibly important picture of the race story within the criminal justice system. And it also led me to question whether or not we could use perceived stereotypicality as a way to understand errors in eyewitness identification. As we know from this literature, errors in eyewitness identification constitute one of the major sources of wrongful convictions in the United States. In fact, one study by the Innocence Project suggested that over 75% of the wrongful convictions identified since 1989 were the result of mistaken identifications. So essentially, if we were able to show that perceived stereotypicality was somehow related to errors in eyewitness identification, it might give us a little more insight into how exactly this process is operating. So let me give you a little bit of background or justification for the study I'm going to be talking about today. Basically, we know from the literature on stereotypes in social psychology that individuals tend to demonstrate a stereotype-consistent memory bias. That is, individuals are much more likely to remember information that is consistent with their stereotypes than they are to remember information that is inconsistent with their stereotypes. We also know from this literature that individuals also tend to fabricate memories that are consistent with their expectations. So individuals can create perceptual experiences that never occurred as long as they're consistent with their stereotypes or their expectations. We also know from the research on stereotypicality that individuals who are higher on stereotypicality are more likely to be stereotyped than individuals who are low on stereotypicality. This suggests essentially that high stereotypicality or individuals who are perceived as high on stereotypicality are more likely to be stereotyped in a variety of different domains than individuals who are low on stereotypicality. And so this led me to question whether or not criminal stereotypes, or that is, individuals' expectations about the likely physical appearance of an individual, maybe that may be somehow related to errors in eyewitness memory. Specifically, when individuals are expecting to see a black criminal, they may systematically influence, or they may systematically change their memory of the suspect such that their memory of the suspect is higher in perceived stereotypicality. Likewise, if someone expects to see a white criminal, it may bias their memory of the criminal in the opposite direction. So in order to explore this possibility, we recruited 116 undergraduate participants to complete a sort of eyewitness identification sort of paradigm. And in doing so, we randomly assigned these participants to see one of 3 different surveillance videos. All of the surveillance videos were identical in content to one another, with one major exception. At the beginning of the surveillance video, participants were exposed to one of 3 different criminal stereotypes. Specifically, participants were led to believe that the suspect was accused of committing a stereotypically black crime, a stereotypically white crime, or they were given no information regarding the context of the video. So aside from that single slide, participants saw the exact same surveillance video. So they're receiving the same sort of a stimuli with the exception of this single slide. Following this, participants completed an identification task. It's a little hard to imagine here, but basically what we did is we created a video that morphed this person's face to this person's face in a period of about 10 seconds. It's quite an impressive demonstration of the software that's available for individuals. If you guys remember the 90s Michael Jackson video, Black or White, basically it's that. We morph the person's face from here to there, and with our hypothesis being that individuals who are exposed to the black criminal stereotype would remember the suspect as appearing more along this line than individuals that were exposed to the stereotypically white crime. And in essence, that's exactly what we found. Basically, participants who are exposed to the black criminal stereotype recalled the suspect as appearing higher in black stereotypicality than individuals who were exposed to either the neutral or the white criminal stereotypes. Both of these bars are significant at the 0.05 level. Interestingly, however, the neutral and the white conditions, while in the hypothesized direction, did not reach traditional levels of significance. So in essence, what we're seeing here, again, is that stereotypes are systematically influencing the perceived stereotypicality of participants' memory. So to sort of summarize what we found here today, is basically criminal stereotypes can have a profound impact on individuals' memory of the suspect. Essentially, what we find is criminal stereotypes lead eyewitnesses to recall an individual as more or less high or low on perceived stereotypicality, depending on the stereotype. Now, this fits very nicely in past research in that we're showing once again that stereotypes can affect individuals' memory. However, where this advances from this literature is it shows that facial features, something that was previously thought as being essentially sacred within this literature, facial features can also be subject to these stereotype-consistent memory biases. Moreover, we've added to the eyewitness identification literature by suggesting that stereotypes about the likely appearance of a suspect can actually systematically influence eyewitnesses' memory of a suspect. And importantly, as I noted earlier, eyewitness identification is once again the major source of errors in wrongful convictions. So understanding these, the source of these errors is very important and has quite considerable implications for the criminal justice system. Taking a step back and looking at how this research relates to the theme of this conference, I think it really raises our attention to the possibilities of committing sort of an intra-group type of color blindness. By ignoring important within-group distinctions, we can essentially reproduce these inequalities and unequal treatments by the criminal justice system. So once again, it's incredibly important to understand the influence perceived stereotypicality has on individuals' treatment with the criminal justice system. Once again, we've seen that perceived stereotypicality affects how individuals are treated basically at all ends of their encounters with the criminal justice system. And I would argue that by ignoring these important within-group distinctions, we would essentially be reproducing these biases. Moreover, I think that this study offers an important theoretical contribution to the literature by expanding our idea and understanding of what exactly constitutes colorblind racism. Essentially, colorblind racism is something that doesn't just influence between group relations. It's also something that can systematically influence individuals' chances within a race. And so on that note, I'd just like to close by thanking my collaborators, Paul Davies, Jen Everhart, and Phil Goff, along with my research assistants who were very instrumental in collecting these data. And finally, the Critical Race Studies program for hosting this symposium. I've been in attendance at the symposium the last 2 years and very excited and pleased to have been able to present my research at this conference. And on that, I'd just like to note that the only way for us to really avoid these consequences is to see race and to see all the aspects and fine intricacies in which race interacts with individuals' experience with the criminal justice system. Thank you.
I think the panelists have gotten us off to a wonderful start, and what I simply want to do now is to ask you for questions. I would only ask that you keep your questions very brief or comments and fire away. So any questions or comments for any of the panelists at this time? Yeah.
Very brief. This is for Danny. I'm curious, I know that you didn't necessarily go this far with your study, but what you said at the end that we should start to see race in this context and in the distinctions. And I'm just curious how you have us do that. I mean, in the criminal justice context, does that mean just keeping statistics, counting dark-skinned black people and light-skinned black people, or is there more to it that you're thinking?
Well, I think first off, we do need to keep statistics on these intergroup distinctions just to track it and to see how influential it actually is in the criminal justice system. Unfortunately, a lot of the research out there suggests that these feature-based or stereotypicality biases are actually quite automatic and very difficult to control, which is a pretty negative story to be telling. Because essentially it suggests that this is a very difficult bias to overcome. That said, I do think a lot of the research that Patricia Devine and others have done suggests that the more aware we are of these subtle biases, the more likely we are to be able to control them. So I think the first steps are really just to get this bias out there and to have people starting to focus on it and raise awareness about the possibility that these intergroup distinctions do have very important policy implications for individuals.
Yeah.
Also for Danny also. You mentioned that part of the surveillance video, the viewers were exposed to stereotypically black crime and stereotypically white crime, and I was just curious what was seen as constituting a stereotypically black or white crime.
Yeah, so we did considerable pre-testing to make sure that we were controlling on a variety of different dimensions. We didn't want to have a stereotypically black crime that was overly aggressive compared to the stereotypically white crime. Likewise, we didn't want there to be socioeconomic differences, a variety of different things. What we wound up settling on was a stereotypically black crime as being a pimp, and stereotypically white crime was an internet hacker. We've since replicated these results in British Columbia with using the stereotypically black crime being an armed robber and the stereotypically white crime as being serial killer. So we see essentially that it doesn't necessarily matter what type of crime we're talking about, just so long as different racial groups are associated with it, it tends to prime these expectations of what the suspect will look like, which then systematically influences participants' memory of the suspect.
Yeah. Karen.
I have two questions, so I can fast. One is for Jordan, one is for Danny. So Jordan, my question is, we have a lot of experience seeing criminal law and criminal procedure as a way of perpetuating racial differences and disadvantage. So I was wondering, the diversity that you talk about, is it degenerative in a way? So I wanted to hear your thoughts about what
So I guess I'll start. Hopefully I'm answering your question. I had trouble hearing from up here. But I think essentially you were asking is the utility of the piece in terms of stopping particular aspects of racialization from happening. Is that?
I was asking how is it useful for, say, white supremacy to have this colorblind face on racial discrimination?
How is it useful for white supremacy to have this colorblind? So I think that how I would answer that question is I actually don't think I actually think it hurts white supremacist organizations to have this colorblind phase. I think that one of the points that I was making in my paper is, and I'm not saying this is a good thing, but I think to answer it from that particular perspective that you're asking, is I think that when race is explicitly linked to the criminality of particular groups, I think that's where we see the individuals who are in control of the indictments and the prosecutions conceptualizing this as criminal street gang in the sense that it's bad types of connections between race and criminality. And so I think that what my project is saying is that the same presumption doesn't apply with group crime generally when you have individuals who are racial minorities in the composition of the group crime, if that makes sense. So I think that in terms of utility, I think that from the perspective of white supremacist organizations, they would think that colorblindness is actually operating against them because in a sense we're othering these types of organizations through the mechanism of colorblindness. Now I think the point that I was trying to get across with, like, for instance, the prescription drug ring is that, which was predominantly comprised of white individuals. I think there was maybe one person based on phenotype and last name where you could conclude that they were Latino, is that that same presumption isn't applying to other types of group crime where we see that whites are, basically the subjects. So I think that's one of the interesting, one of the interesting ways that colorblindness is manifesting itself is that in these organizations that we've othered, colorblindness seems to be working against them, but I don't think that that's, indicative of what's going on with, the generally white group crime, if that makes sense.
Other questions or comments? Oh, sorry, there's another one. Thank you.
As far as using the UCLA undergrad participant pool, it is unfortunate that there's such little diversity in our participant pool here. I believe about 70% of our participants were Asian American. So in that sense, I don't want to overlook the fact that we did have so few other traditional racial groups included in our sample. That said, a follow-up to your second part of the question, and whether or not it's possible that the participants had actually never seen a black person. Maybe it's possible that they've never interacted with a black person, but at the same time, the cultural stereotypes are out there. They see the news. There's numerous studies suggesting that there's a crime script in primetime TV that essentially shows on a regular basis photos of black males consistently in the negative light. So in that sense, people are continually exposed and bombarded with these images of criminal blacks. So I think that while maybe some of the participants may not have directly interacted with blacks, the fact that they're still a product of this culture and this this particular environment, that they will still have been exposed to these stereotypes, and that it would still, as I've shown, it still influences how stereotypically black they recall the suspect.
All right, we have time for one more question. Yeah.
Yeah, if I understood correctly, your response standing to the first question about how to structurally address the problem that you identified was that a cultural shift focusing on the bias would help to begin with, because it was hard to address it otherwise, right? So could we say then that the Obama era, with its color blindness implications, are going to be detrimental to reaching racial equality? Not that I really have never happened, but that is going to move us backwards in that direction in regards to that.
And a footnote on that, I would ask all the panelists in closing to comment on the Obama regime vis-a-vis transition and that they've staked out in their projects. But carry on, then you'll go first.
Yeah, I think, unfortunately, the Obama administration could possibly lead us further down this road of colorblindness. There was a lot of talk in the 80s about the Cosby Show being this possibility of helping out the black community, showing individuals that blacks weren't just criminals, etc. And it tended to sort of backfire on the as far as white racial attitudes went. Whites were able to point to Bill Cosby and say, "Oh, see, blacks are doing fine. They're gynecologists on TV, so everything's fine." And I think we have to be very careful that we don't fall prey to that with the Obama administration and saying we're in a post-racial society since we have a president who is a person of color. So I think we definitely have to be very careful as we're moving along in this administration, and definitely make sure that people are aware that race still matters.
Well, so my few comments on this would be, I think that, as I pointed out in my talk, that Obama is sort of uniquely equipped because of who he is, and maybe that's the main reason why he's able to convey the kind of messages that he has been conveying, and why he's so successful in the statements he makes about race, and that is very positive, obviously, but at the same time, it's the language we talk about, and it's symbolic, and I think that that's just one aspect of it, and it can lead to change eventually, but I think there's a long way from talking about race in a constructive way to actually implementing change in society, and I think it should have become clear also from my studies that this issue of shifting meanings and colorblindness is an issue because there are inequalities, right? Yes. So.
Thank you. Yeah.
I think the question of Obama and his relationship to colorblindness is actually much more complicated than it seems on its face. He's black. He identifies as black. He comes from an explicitly race-conscious history. He identified with race-conscious movements. And while he, to some degree, disavowed that during the campaign, we all know it. So I think it's hard to say what's going to come of his administration in the short term and what's going to come of the ideological shift in the United States and around the world. In terms of domestic politics, he's made some dramatic change. I was a big critic of Obama, and everybody knows this, who goes to UCLA. And I still am. I'm a critical supporter. But he's made some very big shifts in domestic policy, or is attempting to, even in the way bureaucratically the government is structured. The collaboration that's happening between the different entities within the state right now is just, it's really impressive. On the question of empire, I don't think that the presidency has a lot of power. I think that the American state has been an empire historically. It was established as an empire, and it will continue to be an empire until we change that. We, meaning people here and people abroad. I think he's going to change the way empire looks and how we define empire, but I don't think that it's going to change the trajectory of American foreign policy.
So I'll try to end on a more optimistic note. I genuinely do think that colorblindness is going to have more of a presence now that the Obama administration is up and going. But my intuition is that I think that with the increased presence of colorblindness and discussions around colorblindness, I think there's also going to be more of a presence of critiques of colorblindness, such as events as a symposium. And for me, I think it's more just a question of who's going to listen and what audiences are particular fragments of the debate gearing their arguments to. And I think that a lot of what I hope happens is that as, colorblindness becomes more of an issue now, that serious critiques of the concept do really surface so that a lot of the things that we've seen in history don't repeat itself. And so I think in a lot of ways the burden is on us, for those who have problems with that concept, to really make sure that those problems come out. And in terms of it having a greater presence, sure, I think that colorblindness will have more of a presence, but I don't know if that necessarily means that negative change is going to be impeded by that. I think really the burden's on us to make sure that that doesn't happen.
Well, please join me in thanking. I really do mean to say that they've gotten us off to a fantastic start. I'll now introduce the Administrative Director of the Critical Race Studies Program, Professor Sal Sarabia, who will point out some programming matters.
Thank you to Professor Carbato and this wonderful panel for starting us off. So, I want to just welcome you again and just give you a little bit of context. This symposium would not have been created without the energy and the vision of the students in the CRS program, some of whom are in the audience as alumni. And it is part of the reason that the event is obviously a space for us to hash out important questions of the moment related to racial justice and social justice more broadly. But it's also an important community building space for our community. And so if you haven't already made a name tag, I want to encourage you to do that. Say hello to people. Enjoy the next 2 days, really. And as far as logistics, we want to make sure that you maximize your opportunity to engage folks here. And in order to do that, we want to be able to follow instructions, which I actually believe is the hardest thing to get people to do at this event. So I'm going to try to be clear, and if you have any questions, you can ask them. Our next panel is a lunchtime keynote address, one of two that you will hear, one today and one tomorrow. We have provided lunch for all of you so that we could actually use that time to continue our work. And so logistically, this is how we'd like to proceed. We'd like to ask the panelists, both the student panelists and the panelists who are going to be part of the rest of the program, to exit through the doors to my left, your right, and there will be a student volunteer that will lead you to your lunches. And then I would like to ask the rest of the folks who are here with us to wait about 30 seconds and then exit through this door to my right. The goal is to grab your lunch and come right back in here for Professor Crenshaw's talk. Right away. We're going to start no later than 11:45. I'm sorry, 10:45. 11:45. Thank you.